Suppose an engineer designs a new carburetor that cuts petrol consumption by 40%. They have the prototype and the data, and they know the potential market is massive. But scaling that prototype to global manufacturing requires significant capital. If the engineer tries to raise those funds as a sole proprietor, they expose themselves to total personal financial ruin. If the business fails, creditors can seize their home and personal savings to settle the company's debts. To raise money from the public safely, the engineer needs a protective legal shield. They need to manufacture a distinct corporate entity that can absorb the financial risk on its own. Establishing a company involves a meticulous construction process that transforms a private idea into a public legal fiction. Navigating this legal gauntlet requires passing through 3 distinct stages: promotion, incorporation, and finally, capital subscription. This structure allows an individual to pursue high-scale projects while isolating their personal assets from the business's financial obligations. Stage 1 is promotion. The person driving this process is the promoter. Because the corporate entity doesn't exist yet, the promoter holds personal liability for every contract signed and every expense incurred to get the business off the ground. To mitigate that personal risk, the promoter conducts rigorous feasibility studies. The first check is technical feasibility, proving that the raw materials and technology required for the product are actually available. The second check is financial feasibility. The promoter estimates the total capital requirements and determines if the necessary funds can realistically be raised through the chosen organization form. The third check is economic feasibility, which investigates if the business can be profitably exploited in the current market. After confirming feasibility, the promoter must secure a unique name. They submit 3 prioritized options to the Registrar of Companies to ensure the title isn't identical to existing firms or misleading to the public. The promoter carries the full weight of the project's viability and legal liability long before the corporate shield is forged. Once the idea is proven viable, the project moves to incorporation. This is where the company's internal rules and external boundaries are drafted into law. The foundational document is the Memorandum of Association. It acts as the company's constitution, defining its relationship with the outside world and setting the absolute limit of its powers. The memorandum strictly defines the company's name, the state where its registered office is located, its specific business objects, the liability of its members, and the maximum capital it is authorized to raise. Operating within those boundaries are the Articles of Association. These serve as the subsidiary rules for internal management, detailing how shares are allotted, how meetings are conducted, and how directors are appointed. Without these highly specific documents, the proposed company has no legal shape and no authority to undertake business activities. To finalize the entity, the promoter submits the memorandum, the articles, written consent from directors, and the registration fees to the Registrar of Companies. If the registrar is satisfied all statutory requirements are met, they issue a certificate of incorporation and allot the company a unique corporate identity number. This document holds a significant status in corporate law, known as conclusive evidence. Once this certificate is issued, the company legally exists. Even if a flaw is later found in the registration formalities, the certificate proves the company is a valid legal entity that can enter into binding contracts. The date on the certificate marks the exact moment a new, legally distinct person is born into the economy. Although the company now exists as a legal entity, it has no capital to begin operations. The final stage is raising funds. To raise money from the public, the company must get approval from the regulator, SEBI, and issue a prospectus. This document is an official invitation for the public to subscribe to the company's shares or debentures. To protect investors from underfunded projects, the law mandates a minimum subscription threshold. Under SEBI guidelines, a company must receive applications for at least 90% of the total issue size. If applications fall below this 90% mark, the allotment cannot proceed. All money received from applicants must be refunded within 8 days, effectively ending the project. A company must translate its legal status into financial trust. Without hitting that 90% mark, the entity remains an empty shell. If the threshold is cleared and the company receives its certificate of commencement of business, it can finally begin its commercial operations. At this point, the risk shifts. The corporate entity can now choose to adopt the promoter's preliminary contracts, officially moving the liability away from the individual and onto the company. The entity now possesses perpetual succession. Because the company is its own legal person, it can outlive the promoter, the directors, and the original shareholders, persisting regardless of changes in its membership. These 3 stages bridge the gap between private ambition and a persistent legal entity, capable of operating at a scale no individual could achieve alone.